Good morning, ladies and gentlemen. I'm Phil Porter. I'm an attorney with the South Carolina Department of Consumer Affairs. Our subject today is going to be the South Carolina Residential Landlord Tenant Act, an overview. Now, I perhaps have a little bit different perspective than some people because I was an attorney at the Department of Consumer Affairs back when the Residential Landlord Tenant Act was being discussed and debated and was involved somewhat in it. In addition, when I was a student, I was a tenant. When I was also a tenant after I was a student in the early 2000s. And as well, I'm also a landlord since 1985. And I imagine I've probably made most of the mistakes that landlords and tenants make in the time that I've been either a landlord or a tenant or both. So I may have some insights that will help you to avoid some of the mistakes that I've made, and maybe some other mistakes that you could make either as a landlord or a tenant. First of all, we have the disclaimer. This presentation is not meant to serve as a substitute for reading various laws discussed, seeking legal counsel, or otherwise requesting the department's guidance and/or interpretations on the laws it administers and enforces. And I would add here also, the Landlord Tenant Act is not an act which the department administers and enforces. We're aware of it. We can show you what its provisions mean, but we're unable to go into court and try to enforce it either for landlords or tenants. This presentation merely serves as an introduction and an overview. I would also be remiss if I didn't acknowledge the assistance from my colleague, Zach Passmore, because he prepared probably most of the slides on this presentation and did a good job with it, as I think you will see. The mistakes would all be mine. Here's the roadmap. We're talking about the Residential Landlord Tenant Act, and we're going to go over its general provisions, landlord and tenant responsibilities, landlord and tenant remedies, as well as the thing everybody's interested in at the end of a tenancy, which is the security deposits, what can be done with them, what can be done to recover them, and so forth. Now we get into the Residential Landlord Tenant Act. General provisions. It's found in the South Carolina Code of Laws, section 27-40-110. Et sec is just a Latin phrase. It means and as follows, or the following sections count also. Until you get somewhere out of the chapter 40, you'll still be dealing with the Landlord Tenant Act. It was enacted, as I mentioned, back in 1987. Now, back before 1987, when it was enacted, South Carolina law was mostly the South Carolina common law with that came over from England back in the old days, and it mostly favored landlords. There was a bad joke that tenants' rights were very easy to summarize. A tenant has the right to pay rent. The tenant could not withhold rent even if the landlord did not provide essential services like heat and water or repair dangerous hazards. There was actually in Columbia an instance of a landlord in town that had great problems with violating city codes and so forth. And there was a good bit of litigation, but her tenants could not sue her. They had to either pay the rent or be evicted or move somewhere else. That's no longer true. It's not necessarily a tenant's paradise, but it's a great improvement now from the days before 1986 when the statute was passed. It applies to all rental agreements for dwelling units in South Carolina, regardless of where the agreement was entered into, even if it was signed or entered into in another state. However, there are exceptions for detention facilities, medical, geriatric, educational, or religious facilities, transient occupancy in hotels subject to sales tax, occupancy under contracts of sale, or residents at charitable or emergency shelters. Leases. Do you need to have a written lease? Well, the first thing to be said is it does not have to be in writing to be valid. I would caution you, if you are a landlord or a tenant, you probably want to have it in writing. If you're a landlord, you want to have the specifications in writing and understandable. You want to know what your stream of income is going to be and for what time. Certainly, if you're a tenant and you want to be able to stay over a course of time, you're essentially at leave of your landlord every month if you do not have a lease in writing, because as it says on the right-hand side, if there is no writing, generally the tenancy is the month to month. That is, unless you pay your rent by week or bi-weekly, which then means the tenancy is that period. In other words, you can be given a notice by your landlord that you're to leave the tenancy next week if it's a week-to-week tenancy. If the agreement isn't signed by both parties, but the rent is paid by the tenant and accepted by the landlord, it's the same as if the agreement were signed. That means it becomes a contract by performance. Prohibited provisions under the Act are unenforceable so far as those provisions go, but do not necessarily invalidate the entire lease. The entire lease. Now, one of the things that we'll be going over in future slides is that many of the notices and so forth in the Act are required to be done in writing, particularly if they're going to operate against the landlord. Please pay attention to that if you're a landlord or a tenant. What are the landlord's obligations? They must deliver possession of the premises. They must maintain the premises. They must comply with building codes. They must keep the premises in fit and habitable condition. They must make available running water and reasonable amounts of hot water and reasonable heat. In other words, if you're going to have what is considered residential, it has to have at least the most basic services. They must maintain heating, electrical, and plumbing systems. But as we'll see in future slides, that doesn't mean that the landlord pays the utilities for these services. It means that the landlord sets up the access to these services. The landlord must maintain appliances that have been provided by the landlord. That is to say, if you have a window unit, air conditioning unit in the bedroom of your apartment, or if you have a refrigerator in the kitchen, if it breaks, if they break, then the landlord, having put them in and made them part of the bargain, the landlord has the requirement to either get them fixed or get a substitute air conditioner or refrigerator. Note, however, the landlord must make the property available with these features and repair as necessary, but has no obligation, once again, to pay utilities unless it's separately agreed to. The landlord of a single family residence may agree in writing with the tenant that the tenant will perform maintenance of premises, including things like lawn care. Now, there's some case law interpretation under the Landlord Tenant Act. And you'll note that the courts are still fairly conservative in construing the Act, and mostly because there are a limited number of things that the law actually requires. We first talk about Robinson versus Code. This was a tragic situation where there was a fatality because the apartment either didn't have smoke detectors or the smoke detectors were not in working order. The court ultimately found, the appeals court found that even though ordinances required detectors, there was no liability under the Act, because under those ordinances, there was no implication of negligence necessarily, and the Landlord Tenant Act itself did not require any action without notice that the detectors were absent or not working. All right, in Thompson versus CDL Partners, the landlord had to be given notice of a defect to be liable for failure to make necessary repairs. In Fair versus United States, the landlord's duty under the statute to keep the premises fit and habitable applies only to physical characteristics. The tenant himself or herself needs to keep premises reasonably clean and for other safety concerns. That case actually involved a situation where the landlord provided fit and habitable tenancy. However, a tenant within the complex had a dog and allowed the dog to attack another tenant in the complex. And it was found not to be the fault of the landlord, but it's fault of the tenant who let its dog run loose. In Pryor versus Norwest Apartments, the landlord did not breach a duty of keeping the premises safe where the tenant slipped and fell in a muddy area, which was considered to be obvious, which was also a common area to all tenants. What are tenants' obligations? Tenants must comply with all building and housing codes impacting health and safety. If you don't necessarily know before you enter into a contract with a landlord what your community's codes involve, you might want to check into it. The fact is, with regard to these codes or any law, a citizen is held to know what is in the law and is liable for not complying with the law, whether they actually read the law or not. The tenant must keep the premises safe and reasonably clean. The tenant must dispose of garbage in a clean and safe manner. The tenant must use facilities and appliances in a reasonable manner and not use them for purposes unintended for those appliances or facilities. The tenant cannot deliberately or negligently destroy or damage premises or personal property included within it. The tenant cannot disturb other tenants' peaceful enjoyment or neighbors' peaceful enjoyment or allow visitors to do so. The tenant must comply with lease rules and regulations. Now, there is not unlimited ability on the part of landlords to make rules and regulations. They cannot be unfair or unconscionable. They cannot violate the law, and they cannot seriously impact the value of the contract that the tenant may have already signed. But otherwise, if they meet these requirements, rules and regulations can be imposed on tenants. Tenants must occupy the dwelling unit solely for that purpose and no illegal activities permitted. In addition, part of the rules and regulations may be if there's a home business involved, usually if it's just a matter of dealing with things on the computer and the internet and so forth, there's no objection. But if it means that there's going to be a lot of going and coming of customers and people at various hours, there may be some limitations on that would be legal. The rules and regulations. As I said, the landlord may adopt rules and regulations, but to be enforceable, the rules and regulations must promote safety of tenants or promote the preservation of the property from abuse. They must apply to all tenants in a fair manner and be applied in a fair manner to tenants, not in favor of some and against others. The tenant must be given notice when renting or when the rules are adopted by a landlord or a subsequent landlord. If adopted after the tenant enters into a rental agreement, the rules must not substantially modify the tenant's obligations for the term of the lease, and the tenant has to be given 30 days notice in writing to be able to object if they choose to. Access to premises that the landlord must give. The landlord can enter the premises without consent under certain circumstances. Anytime in the case of an emergency, Examples of this: if there is a hurricane expected and the landlord needs to board up windows or the like, or a pipe has burst and is filling the basement or the crawl space with water. Those are emergencies. The landlord can enter between 9 a.m. and 6 p.m. for regularly scheduled periodic service, providing the right to enter is written in the agreement and the landlord announces the intent to enter with 24 hours notice. This would be things like spraying for mosquitoes or spraying for palmetto bugs, which in parts of South Carolina are always a problem, or for example, changing the filters to air conditioners or heat pumps. Between 8 a.m. and 8 p.m. when providing service the tenant has specifically requested and landlord announces the intent to enter with 24 hours notice. Now, of course, one of the things that can happen here is if it's one of these last two situations and the landlord gives notice, the tenant can also say, well, you can come this afternoon if you want to, if the tenant agrees to it. Same thing with the services the tenant has specifically requested, which they usually will want to have happen as soon as possible. The landlord must not abuse the right of access or use it to harass the tenant. The tenant must not unreasonably withhold access, including letting the landlord show the premises to prospective buyers or prospective tenants shortly before the lease expires. The tenant cannot change locks without permission. What are tenants' remedies? The tenant must give a landlord written notice of non-compliance materially affecting health and safety or physical condition. There's a hole in the wall, the roof leaks, etc., etc. Notice that the notice must be written. That's going to be emphasized, and it has been emphasized in various parts of this presentation. That's because the law requires it. And if you simply say to your landlord, I need something done about thus and such, you may not be able to hold it against the landlord if it goes to court. Examples: broken locks on doors, broken windows, structural damage, water damage, lack of smoke detectors. Courts typically treat a violation of building codes as an implicit violation of the lease by law. Some of these will be the responsibility of the landlord. Some of them, however, may be the responsibility of the tenant. The landlord has 14 days to remedy the breach, which seems like a lot of time. The tenant has no right to withhold rent during the 14-day period. And note this, staying in the apartment almost always means that the rent will be deemed owed if it goes to court or it goes to a dispute. The tenant can terminate the lease agreement if the landlord fails to make repairs timely. That is, unless for breaches not directly impacting health or safety. If the landlord begins to make repairs within the 14 days and completes them within a reasonable time frame, and that's not explicitly explained, the lease agreement will stay in effect and the tenant will not be able to terminate the lease unilaterally. If the agreement is terminated, the landlord shall return the security deposit, assuming that there are no other damages or other reasons for deducting from the security deposit. Tenants cannot terminate leases if their own actions or those of their family members or guests caused the need for repairs. What if the landlord fails to deliver possession? No rent is owed until possession is delivered. Tenant can terminate the agreement upon at least 5 days written notice, once again, written notice, and the landlord must return any prepaid rent and any security deposit. Or the tenant can demand possession and bring action against the landlord and any person possessing wrongfully. The tenant may be entitled to actual damages, and landlords are not liable for damages if they make reasonable efforts to obtain possession. Now, How does this come up? It comes up if, say, for example, that a tenant has previously held a tenancy in the apartment, fails to leave as they are supposed to at the end of their term. Well, in some of those situations, the landlord doesn't have the ability to just physically walk in and push people out. The landlord may need to go to the magistrate, and sometimes they're hesitant to do so. But this gives the prospective tenant, the new tenant, the ability to go in and get both of those parties before the judge, and the judge will be able to decide who needs to have possession. Failure to deliver possession continued. If the failure to deliver possession is willful and not in good faith, the tenant may recover the greater of 2 times monthly rent or 2 times actual damages. Well, you may ask, well, what's the difference between those two? Well, we know what the monthly rent would be. If the monthly rent was $1,000, that's $3,000. But if the tenant sues for actual damages, it's always possible that that tenant under short notice is going to have to get more expensive accommodations. So if that tenant has no ability to do anything other than get, say, an apartment, a substitute apartment at $2,000 a month for 2 months, then that measure of damages would be $4,000. The tenant can also recover reasonable attorney's fees. Wrongful failure to provide essential services. What are essential services? Running water, reasonable amounts of hot water. You can't necessarily wash your car with hot water. Plumbing, sewer access, gas when used for heat, hot water or cooking, electricity, heat. We mentioned air conditioning again. If you want to have air conditioning, make sure it's either in your contract or that the machinery for the air conditioner is part of the tenancy when you look through it. Because if it is there, it is probably something that the landlord will have a duty to maintain. If it is not there, it's certainly not clear under the Landlord Tenant Act that it's something that is required if it has not been provided for contractually. If the landlord is negligent or willful in failing to provide essential services, the tenant may give written notice to the landlord. The tenant may then procure reasonable amounts of the essential services and deduct that money from rent. Alternatively, the tenant may recover damages for diminished market value and attorney's fees, though of course this means going to court. The tenant's rights do not arise until the tenant has given written notice to the landlord and the landlord fails to act within a reasonable amount of time. Once again, tenants do not have these rights if their deliberate or negligent actions or omissions cause the problem to begin. A landlord's noncompliance is defense for action for eviction. If an eviction is based on non-payment, the tenant may use the landlord's noncompliance as a defense or counterclaim. The tenant, of course, should have given written notice to the landlord in order to make this claim, and is considered to have waived the violation if no notice is given. I'll give a secondary caution to any tenants in this situation. If you're in an eviction action, the eviction action is going to be decided. So you better be pretty sure that you have a defense or counterclaim against your landlord that's going to work, because one of the possibilities, what's on the table, is eviction, and that may be the judge's decision. So it's always best to try to work out the situation with your landlord ahead of time. Fire or casualty damage. If the dwelling unit is damaged or destroyed by fire or casualty to the extent that normal use and occupancy is subsequently impaired, then the tenant may immediately vacate the premises and notify the landlord in writing within 7 days of the intent to terminate the rental agreement. Landlord must return security deposit and prepaid rent unless fire or casualty was caused by tenant's negligence or otherwise, or if there are some sort of other damages that are meant to be covered by the security deposit. The tenant may also vacate any part of the property rendered unusable by the fire or the casualty. Tenant's liability for rent is reduced in proportion to the diminished value of the unit. But bear in mind, this is an item that quite often there would be disagreements about it as to what the value would be. And in order to get this determined, you might well need to go to court. Remedies for unlawful ouster or exclusion. If the landlord ousts or excludes tenants by failing to provide essential services, the tenant may recover possession or terminate the agreement. Tenant may also recover 3 months' rent or 2 times actual damages, whichever is greater, and attorney's fees. Landlord remedies. If a tenant's breach is due to something other than non-payment of rent, the landlord must give notice of the breach and state that the lease agreement may terminate within 14 days. Usually this will be some sort of thing that is torn up with allegedly the fault of the tenant or something like that. If the tenant remedies the breach, in other words, fix whatever the problem is that's non-compliant, if he fixes that breach in the time period, or if he cannot remedy the breach within that time period, but begins the remedy, kind of like the landlord could do in the other situation, the lease agreement continues. If the tenant's non-compliance affects health and safety and requires repair, the landlord has the option to enter the premises and commence repair and be reimbursed by the tenant rather than terminate the lease. Failure to maintain health and safety standards is basically an implicit violation of the act, and the landlord can be, in some cases, be cited by authorities if the tenant has accumulated garbage or unclean conditions. However, if the problem is not remedied and the landlord gets ticketed by the fault of the tenant can then be evicted. Non-payment of rent. If the tenant hasn't paid rent when due or within 5 days of the due date, the landlord may terminate the lease agreement by giving notice to the tenant. Written notice must only be given once per lease period. This cannot be emphasized enough to tenants. It need only be given once. If I'm 6 days late and my landlord gives me a notice that will not be tolerated without eviction or termination the next time, that's the only time I'm entitled to it. I'm not entitled to be 5 days late again and again. It also can be used or included in the lease agreement. And if so, the tenant will be considered automatically on notice. So the tenant should never assume that the landlord cannot terminate until the rent is demanded if the rent is already more than 5 days past due one time. Now, the statute gives suggested language for this. The citation is there, and I can tell you most landlords are going to use that very language in the contract itself. Personal property. After an eviction, the landlord can remove tenant's personal property from the premises. Notice must be given to the tenant. If the premises is abandoned or rental period is over and the tenant has removed a substantial portion of the tenant's property, or if utilities are voluntarily terminated by the tenant and the personal property remains, then the landlord must make a choice, or at least make a decision. If the landlord believes the fair market value of remaining property is less than $500, the landlord may enter and remove the property. If it appears that the fair market value is greater than $500, the landlord must go to court through the ejection process, but the landlord is not liable for underestimating the value unless it's grossly wrong. If needed, the landlord may use force to enter the unit if, for example, if it's abandoned and yet the tenant has changed locks. That could mean breaking locks or breaking windows if necessary, and that would generally mean that any security deposit will be dinged for that if has not already been. Absence, non-use, or abandonment by tenant. This is defined as an unexplained absence for 15 days after default of payment. If the tenant voluntarily terminates utilities and there's an unexplained absence after default, the landlord does not need to wait 15 days. The landlord must make reasonable efforts to rent the property at fair market value. Security deposits. When a tenancy is completed, the tenant needs to give the landlord a written request asking for the return of the security deposit. The tenant must provide the landlord a forwarding address. The landlord has 30 days to respond. The choices will be to refund the money or to provide an explanation of any money that's withheld, such as accrued unpaid rent, damages to the premises caused by the tenant, and so forth. If the landlord fails to respond, the tenant can bring an action for 3 times the amount wrongfully withheld and attorney's fees. Retaliatory conduct by the landlord is prohibited. The landlord cannot raise the rent above fair market value or decrease essential services or bring an action for possession if the tenant simply complains to government agencies about housing code violations or the like. If the landlord acts in violation of these requirements, the tenant may bring an action for possession. Any landlord who acts in retaliation is liable for damages up to 3 months' rent or 3 times actual damages, whichever is greater. Tenants' rights in foreclosed property. There's actually a federal law that protects tenants' rights in foreclosed property. Let's say your landlord was unable to pay the mortgage and the property goes into foreclosure. If the tenant has a written lease, it will survive the foreclosure of the owner for any mortgage, which is a federally related mortgage loan, which means that is a federally chartered or a federally insured or guaranteed lender, or a lender that makes loans, mortgage loans totaling $1 million or more. Now, there are exceptions to this, but what it means is if your landlord gets foreclosed when you are 6 months into a 12-month lease, you get to stay the full 12 months. The exceptions are this: if the new buyer in foreclosure intends to live in the home as a primary resident, the tenant gets 90 days to move. Likewise, if the tenancy is month to month, the tenant still gets 90 days to move. Magistrates Court. Magistrates have concurrent jurisdiction over landlord and tenant matters, although they hear the vast majority of residential landlord-tenant matters. Eviction actions have short notice periods. The department attorneys and complaint analysts get complaints from consumers from time to time. Essentially, I've got a hearing at 2 o'clock today for evictions. What do I do? Well, you better show up. The problem, as I've mentioned, is the department's unable to represent folks in court and assist them in eviction. And in fact, not being able to afford the rent is not going to be considered a defense. Although, in my experience, sometimes if the tenant shows up, explains the situation, asks for another week or so to either get the money together, the arrearage together, or otherwise get their belongings out of the tenancy, then the magistrates may listen to that. But if you don't show up, there's going to be an eviction. Appeals of these cases are to the circuit court. I can't emphasize this enough. I probably should have several exclamation marks. Read the lease. Read the lease. The Act sets forth only basic requirements for landlords and tenants, but almost anything that is not specifically required or forbidden by the Act can be a matter of bargaining between the parties. The tenants should never assume that the landlord has obligations not specified in the act or in the lease itself. For example, we've mentioned the utilities. Cable and internet are usually at tenant's expense unless the landlord commits to them in writing. Likewise, while the landlord must provide access to essential services, it's the access that is important. The landlord is not obligated to pay the bills unless it is in the lease. Other considerations. We've mentioned ordinances and city requirements or county requirements. They may be varied. City of Columbia has ordinance that require such things as smoke alarms in all hallways and all rooms used as sleeping quarters. For complexes with more than 4 families, the alarms must be hooked into the electrical system as well as batteries. Outdoor steps and porchways must have handrails that are done in a certain ways to avoid people falling over, but also avoiding having children get caught in them. Outlets near sinks and baths must have ground fault interrupters to avoid electric shocks to people. Landlords must apply for permits each year and sign statements that various features of the unit are in fit and safe condition. Frequently asked questions. My landlord never gave me a new lease when my year was up. Can I stay in the unit for another year if I want? Answer is probably not. If you want to be sure you can stay for an extended time, you need to ask the landlord for a written lease. Without a written lease, the landlord can choose to give you 30 days notice to vacate. Unless you pay weekly, then the notice may be only a week or a little more than a week. Can I break my lease if my landlord sells the place? Answer is, it depends. Once again, read the lease. If it allows termination by both parties upon sale, that will be binding on the new buyer as well as your landlord. If you wish to check with the new owner anyway, you may wish to check with the new owner anyway, as most landlords will be satisfied to have a steady flow of rent, at least for the time being. If the lease contains no right to terminate on sale, the law states that the buyer's rights are the same as if the buyer was the landlord, and then when the lease was first signed. Both parties will be obligated to the end of the lease term. Question is, I have a friend who saw a model apartment in a complex, was assured that the apartment that he was getting would be the very same thing. When he got the keys, the place was all beat up, worn and stained carpet, doors that wouldn't close, and not really the same thing. Can a landlord make you sign a lease without seeing the apartment? Well, the answer is, landlord can't make you, but he does make you if you let him make you. So the answer is no, but you can short circuit that. If a landlord suggests that you rent based on a model, you might say, you seriously expect me to pay deposit and move into next week into an apartment that I've not seen? In most leases, the landlord is going to have reserved the right to show the apartment, even if someone's still in the apartment from a prior lease. So either tell your friend's story and say you're not going to do that, or say I'm going to take a bunch of pictures and make sure everything that is in this model is going to be in my apartment too. What are the other resources? Well, you've got the legal services line. South Carolina Legal Services assists people of limited incomes in certain legal matters, which may include things like matrimonial law or foreclosures or landlord-tenant disputes. If you call them, they can give you the outlines of what they can and cannot help you with. There's a law help line there also that's on the internet. The South Carolina Bar has a lawyer referral service. Now, what happens with the lawyer referral service, and you can call that number, is that in some cases, they'll say you can get a half hour or an hour consultation with a lawyer that practices in the area that you're inquiring about. In some cases, they will ask for a $50 fee for that service. But in some cases, particularly if you're just looking for answers on landlord-tenant, the attorney may or may not give you sort of a seat of the pants notion of what your rights and responsibilities might be. South Carolina Law Answers is another internet opportunity for consumers. Now, if you want to get familiar with what the procedures and the mechanics are in landlord-tenant disputes or evictions, you can consult this bar publication, which gives information on magistrates' courts hearings. Or you can call the Department of Consumer Affairs if you're aware that we will answer questions that we can answer and put you through to other sources for help. But still in all, this is not one of Landlord-Tenant Act is not one of the areas where the department's attorneys can represent you in court.